Clerk calls the case, People versus John Fulton.
We're ready.
Before a single defendant speaks, this courtroom already tells us what kind of day this will be. This is not a trial day. This is a docket day. The backbone of the criminal justice system where lives move forward or stall in minutes. No juries, no closing arguments, just structure, control, and accountability. What matters here is not emotion, it's compliance. You're about to see Judge Simpson manage dozens of cases with one consistent message. The court will move forward whether you're ready or not. Adjournments are allowed, excuses are heard, but responsibility is never suspended. As you watch this first case, pay attention to how little time defendants actually get to speak and how much power the court still holds. This is where consequences are shaped quietly, without drama, but with long-lasting effects. Ask yourself this as we begin. Should justice move fast to stay efficient or slow down to stay humane? Because today, efficiency is winning.
Deputy Chief Public Defender, thing on behalf of Mr. Fulton, he's in the lockup, should be on his way out. Your Honor, today is the date and time set for the probable cause conference. I believe that we've adjourned this matter because we're waiting for a mitigation report. That mitigation report is almost complete, so we'd ask for one more adjournment. We've got the final piece of information we need.
Probable cause conference, May 29th, 2025, 9 a.m. Bond continued.
Thank you very much, Your Honor.
Court calls case, People versus Demond Bransford.
Brian Bowling on behalf of Mr. Bransford.
Your name, sir?
Demond Bransford.
Thank you.
I have a green sheet, Judge.
Requesting an adjournment.
I am, Judge.
We adjourn to May 29th, 2025, 9 a.m. Bond continued.
Your Honor, may I address one issue of bond? Would the court allow an order for him to be released to a treatment if it becomes available?
If I get that order, I will sign off.
I will submit it. Thank you, Judge.
Thank you. Court calls the case, People versus Alan Franklin.
Alexander, on behalf of Your Honor.
Morning, Honor. May it please the Honorable Court, David Burgess on behalf of Alan Franklin.
Your name, sir?
Alan Franklin Jr.
Thank you. All right, what are we doing?
Your Honor, I was going to ask for an adjournment. I was just received this case Tuesday. I do not have discovery yet. I know I can't fill out a green sheet from Zoom, but I apologize. But just 2 weeks, Judge.
Turn this out May 29th, 2025, 9 a.m. or as your invite indicates, bond will continue. All right,
Thank you, Your Honor.
I'm sorry, I still will wear this tether or the
Pardon?
GPS. I still wear the GPS.
You still have to have the GPS on.
Okay, that's all I need to know. Thank you.
Okay, thank you.
This exchange is short, but it's powerful. The defendant asks a yes or no question, and Judge Simpson gives a yes or no answer. No explanation, no debate, no negotiation. GPS monitoring exists because trust is already limited, and the fact that the defendant asked tells us something important. People often hope conditions are flexible. Courts do not share that view. Judge Simpson reinforces a core rule of supervision here. Compliance is not optional, and clarity is intentional. The court does not soften language because confusion creates loopholes. Audience question: if someone has not violated yet, should strict monitoring stay in place? Or should compliance earn gradual relief? This judge clearly believes structure comes first.
Court calls the case of the People versus Rick Artuso. Artuso?
And good morning, Your Honor. Assistant Public Defender Timothy Carrier on behalf of Mr. Artuso, who is approaching. Mr. Artuso, state your name for the record, please.
Rick Artuso. Thank you.
Your Honor, I do have a green sheet. We're asking for an adjournment. We're currently in negotiations with the people. I would like to also address bond, please.
Matter will be adjourned May 29th, 2025, 9 a.m. Yes.
Your Honor, in regards to bond, we're asking Mr. Artuso, well, Mr. Burgess is on one of his matters. I apologize.
Okay. Good morning, Your Honor. May it please the Honorable Court, David Burgess on behalf of Rick Artuso as the other matter.
All right.
So, Your Honor, in my matter, Mr. Artuso has $1,000 10% bond that was set. He does have a cash or surety bond in Mr. Burgess's matter. Mr. Artuso, it seems as if he was He went into bench warrant status on Mr. Burgess's matter because he failed to appear to court. He did indicate that he came to court on that date, but he was under the impression his court date was set for 2:00. When he did come, he stated he was here until the building closed and he left. Unfortunately, at that time, our office was not on his case, so he didn't call us. I'm unaware of his communications or if he was able to communicate with Mr. Burgess. So there was no opportunity to have a bench warrant recall.
So how did he come back into custody?
You said you were just in the car that was pulled over.
Yes, I got pulled over. But
So he was arrested on the bench warrant, Your Honor. There are no new charges. Mike,
So why didn't he come back to court?
I did ask him that as well.
Okay, and what was the answer?
He did not have an explanation, Your Honor.
Okay.
It was,
Go ahead,
So
I'm
the-
listening.
he did not have an explanation as to why he did not come back to the court, why he did not, contact the court to let them know that he tried to come. I did explain to him in the future, if he's got any issues with his court dates, that the clerk's office is right there at the front, that all he needs to do is speak with them and they'll advise him properly. The issue that we're having is in our case, the resolution that we're seeking to reach would require that he pay some restitution up front. Unfortunately, with him being in custody, Judge, he will not be able to do that. He is hopeful that the court would consider giving him a PR bond. I understand if a GPS tether is necessary to ensure his return to court. He has very minimal criminal history, to my understanding as well.
This is where intention clashes with credibility. The defense presents a reasonable sounding argument. Release him so he can work, raise money, and resolve the case. But the court isn't persuaded, because this defendant already failed to appear once. From a legal standpoint, missed court equals broken trust. And once trust is broken, promises lose weight. Judge Simpson focuses on behavior, not plans. Here's the audience question. Should courts prioritize financial restitution or court compliance? Because sometimes those two goals collide. And when they do, this judge makes it clear which one wins.
But I'd like to see if he could get out so he could raise some money and pay off this restitution so we could get a resolution.
Response from the people.
I would leave it up to your discussion.
If he doesn't appear, doesn't come back, it's got to be picked up. It's going to sit until we can get it resolved. Motion for bond reduction denied. Bond will continue.
Understood, Your Honor. What do you need to say?
I was gonna ask you, Your Honor, worst comes to worst, I know I could, it's Thursday, I'm scheduled to be married on Sunday, I could come in Monday and I could pay restitution, whatever it takes to pay.
Scheduled to do what?
Married this Sunday.
That is true, Your Honor. He did inform us of that. I don't know if his fiance and his mother are here, but prior to his being picked up, I think he was scheduled to be getting married this Sunday.
I'm not going to use that as a basis to. I mean, the problem is that you should have come back down to the court. If you waited here all day, you should have come to the court at some point, but we had to pick you up, bring you in. I'm not doing that again.
That sentence ends the discussion. The judge acknowledges the explanation and rejects it. Not emotionally, not angrily, just firmly. A scheduled wedding does not outweigh a court order, and allowing it to would create unequal justice. Judge Simpson draws a boundary not just for this defendant, but for everyone watching. This is the court saying, life does not pause legal responsibility. Ask yourself, should personal milestones ever matter in court decisions? Or does consistency protect fairness for everyone else who followed the rules?
Thank you.
Thank you, Your Honor.
Court discussion case of me versus James Clark.
Good morning, Your Honor. Andra Sabri requesting permission to practice pursuant to Michigan Court Rule 8.120 under the supervision of Assistant Public Defender Chinazai Kiri Akinruli, representing client Kyle Clark, who is present in person today.
Second release is the one that's supervising you?
That's correct, Your Honor.
How's that going?
It's going very well.
Is it?
Yes.
You don't know a whole lot, so you don't know, right? Never mind. Permission to practice is.
Thank you, Your Honor. Mr. Clark, please state your first and last name for the record.
Chen Clerk.
Thank you, sir. All right, what are we doing?
Your Honor, we respectfully request that this matter be set for a preliminary examination.
All right, all discovery is complete.
To my knowledge, Your Honor.
People have their witnesses available the 27th.
We'll do our best, Your Honor.
Preliminary examination in person, May 27th, 2025, 9 a.m. That will be before Judge Fresh Hour. Bond will continue. Thank you, Mr. Clark.
Thank you, Your Honor.
Court does call the case of the people of the state of Michigan versus Jeffrey Murphy.
Good morning, Your Honor. Assistant Prosecuting Attorney, Madison Peaceful.
Ray.
Morning, Your Honor. May it please the Honorable Court, David Burgess on behalf of Mr. Murphy.
Marie Tanha, AKA the phone.
Again, Your Honor, I apologize. Someone dared call my work cell.
What? Somebody called your work cell? I think it was somebody over there. They just. All right. Okay, what are we doing? Your name, sir?
Jeff Murphy.
Thank you. What are we doing?
Your Honor, discovery is complete in this matter, requesting exam be held.
People have their witnesses available the 27th?
Your Honor, if I may have a moment.
Yes.
Your Honor, I do want to bring up something else that's concerning this case, and at this point, I'm hoping that the court can warn the defendant. I'm sure Mr. Burgess will speak to him as well. Part of this case is defendant posting naked pictures of the victim. Not that they should be anywhere, but certainly places that have put her at risk. They have since been taken down, is my understanding. So if the court wouldn't mind issuing a warning to the defendant about ensuring that does not happen again.
This is no longer about procedure. This is about victim protection. Posting explicit images is not just misconduct, it can be intimidation. And the prosecutor is careful here. She asks for a warning, not sanctions, placing the defendant on formal notice. A court warning is not casual. It creates a record. And if this behavior happens again, the consequences escalate fast. Bond revocation, new charges, or both. Viewer question: should warnings be enough in cases involving potential victim harm, or should courts act immediately before damage multiplies?
And I believe Mr. Burgess is well aware of what I would do if this happens again, so he can have a conversation with his client about.
All right. So these came up after the charges in this case?
Let me double check. Your Honor, we don't know the exact date. I have to look into that.
Okay, but they have since been taken down.
Yes, it's been taken down, which is why I'm asking for a warning as opposed to.
All right. You understand that, sir?
Yeah, yes.
All right. And Mr. Burgess, you're gonna have a more detailed conversation with him about that?
Yes, I will, Your Honor. I'm well aware of what Ms. Tanner will do if that's the case. If he does it again, if it happens again, if it did happen in the first place, Your Honor, so.
All right, very good. Okay. And with the people
That's a good date, Your Honor.
that will work,
Thank you, Your Honor.
preliminary examination in person, May 27th,
Have a good day.
2025, 9 a.m. That is before Judge Washington. Bond will continue.
Thank you.
Let's call the case of the people versus Frank Clark.
Okay, I'm sorry, Your Honor. I apologize. Can we recall that previous case? Apparently I wasn't clear,
Okay,
if you don't mind.
you weren't clear? Okay. I guess, can we get him back?
I agree with your defendant feels it's appropriate.
Well, hold on a second, because I lost Mr. Burgess.
I can call Your Honor.
Okay, so when he appears, we'll get him back out at some point.
I'm
And
in the
can I
court.
have-
I'm in the court. I'm in the court.
Morning, Your Honor. Mike Gaddy, Assistant Public Defender for Mr. Clark, who's in the court.
Yeah. Thank you, Mr. Clark.
Douglas for the people.
Your Honor, I'd ask the court for a brief adjournment in this matter. We're still talking with the prosecutor in hopes of a resolution.
Probable cause conference will be adjourned May 29th, 2025, 9 a.m. Bond continue.
Thank you. I'll give you a call, Mr. Clark.
Thank you, Ms.
All right. Take care.
Court calls the case people versus Scott Jenks.
Yeah, then on behalf of the people, Your Honor. Stephanie Can on behalf of Mr. Jinx.
What's up with Cannon's clients?
It's Thursday, Your Honor, so the good news is I do have a plea in this matter, which I can hand to the court and the plea form.
Hold on back there. Who do they have?
They were bringing back the other gentleman,
This Jenks?
Stephanie Cannon on behalf of Mr. Jinx. Mr. Jinx, please state your name.
Scott P. Jenks.
I have before me a plea form that indicates that the defendant will be pleading to count 3 to domestic violence was sentencing under 4A, that's the stated count 3. And defendant will seek alcohol treatment. He will also be pleading to an added count 4 of attempted resisting and obstructing a police officer to a 1-year offense. Upon his successful plea to those 2 charges, counts 1 and 2 would be dismissed. That's the court's full understanding.
That's correct, Your Honor.
Your Honor, that is my complete full understanding of the agreement.
May I have him sworn?
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
State your name.
Scott B. James.
All right, sir, it is this court's understanding that you are going to be pleading guilty to 2 charges. Is that your understanding?
Yes.
Yes.
Speak up for the court. to hear
Yes,
you.
sir.
The first charge is that of domestic violence. That's a misdemeanor punishable by up to 93 days in jail, $500 fine plus court costs. You understand that, sir?
Yes, sir.
This is where courtroom reality replaces speculation. When judges state penalties out loud, it's not just formality, it's informed consent. A plea is only valid if the defendant fully understands the consequences. Judge Simpson carefully lays out exposure, jail time, fines, court costs. Nothing vague, nothing implied. This protects the plea from being challenged later. If the defendant appeals claiming confusion, this record shuts that door. What's important here is that misdemeanors often sound minor to the public, but 93 days in jail is still incarceration, still job loss, still life disruption. Viewer question: do people underestimate misdemeanor pleas because they don't sound serious? And should courts do more to emphasize long-term consequences beyond jail time?
The second charge is that of attempted resisting and obstructing a police officer. That's a misdemeanor punishable by up to 1 year incarceration and $1,000 fine plus court costs. You understand that?
Yes, sir.
All right. You understand, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Freshour in the 14A4 District Court. You understand that?
Yes, sir.
All right. Understanding all of that, do you still wish to plead guilty?
Yes, sir.
To the charge of domestic violence, how do you plead?
Yes, sir.
To the charge of attempted resisting and obstructing an officer, how do you plead?
Yes, sir.
How do you
You gotta
plead?
say guilty.
Guilty.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
Can you hear him?
I have heard.
You're okay. We can get some equipment. So let's do that.
Okay.
All right. Is that better, sir?
Yes, sir.
Okay. So up until that point, you heard everything else that I said.
Yes, sir.
Is that correct? All right. So you understand that by pleading, well, I think I was at the plea. So let's just make sure we have that. To the charge of domestic violence, how do you plead?
Guilty.
To the charge of attempted resisting and obstructing, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
Yes, sir.
You signed an advice of rights form, is that correct?
Yes, sir.
Any question regarding any of those rights?
No, sir.
Look at paragraph 5 on that form. You'll see a copy on the podium. I'll let you get your glasses. Those are your rights, which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, sir.
You understand you're giving up your right to appeal of right.
Yes, sir.
Are you on probation or parole?
No, sir.
Has anybody promised you anything other than what's been stated here today on the record to get you to plea?
No, sir.
Anybody threaten you or coerce you?
No, sir.
You're doing this voluntarily
Yes, sir.
of your own free will,
Yes, sir.
and because you believe that you're guilty of these offenses?
Yes, sir.
April 20th, 2025, at the location of 418 North Point Drive, Northfield Township, Washtenaw County, State of Michigan. What did you do involving a Betty Jane Jinx that makes you think that you're guilty?
We got in an argument based off of a family member on her side that was making racial,
Your Honor, may I have water?
excuse me?
Yeah.
Go ahead.
You got in an argument with your wife
Yes, sir. Ma'am.
and you guys were married, living together?
Yes,
This was at the family home?
yes,
And during that argument, did you push her onto the couch?
yes, yes, ma'am.
Ultimately, the police were called?
Yes, ma'am.
And when the police were called, they attempted to arrest you and you pulled your hands back such that they had a hard time arresting you?
Yes, sir. Yes, ma'am.
Your Honor, I do believe that's sufficient basis for the plea.
All right. You didn't have her permission to push her down on the couch when you did that, did you?
No, sir. She was pushing me. I was just trying to get her off of me. I didn't shove her real hard.
Oh, that kind of slingshotted around.
Yes, yeah. So, but again, you were having an argument
Yes, ma'am.
and you did push her.
Yes, ma'am.
You didn't have permission to push her, true?
Yes. Yes, sir.
Yeah, okay, sir, you do realize that I'm not saying it would be successful, but you may be able to assert self-defense in this matter?
This is a critical moment, and an uncommon one. The judge is pausing the plea to protect the defendant's rights, even when the defendant is ready to plead guilty. That tells you how seriously the court takes voluntariness. Self-defense is a complete defense. If valid, it can result in acquittal. By raising it, Judge Simpson is ensuring the defendant is not pleading guilty out of confusion, pressure, or fatigue. This protects the integrity of the court more than the defendant. A plea entered without awareness of defenses is vulnerable on appeal. Viewer question: should judges intervene like this more often, even if it delays resolution? Or should defense counsel bear that responsibility alone?
I don't want to hear your comment on that. You understand
Yes.
that is a possibility?
Yes, sir.
All right. Do you want an opportunity to discuss that with your attorney? Because as it stands right now, I cannot accept your plea.
Okay. Yes. Yes, sir.
Want some time to do that? All right.
Yes, sir.
So let's take him back and I'll bring it back out later.
Thank you, Your Honor. Thank you, Your Honor.
Court calls the case, People versus Deshaun Clifton.
Stephanie Canna on behalf of Mr. Clifton.
Your name, sir?
Deshaun Clifton.
Thank you. You're requesting an adjournment.
Yes, sir.
Probable cause conference, May 29, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Court calls the case, People versus Richard Johnson, the second.
Hannah Mackey on behalf of Mr. Johnson, who was to my right. Please state your name for the record.
How you doing today, Your Honor? Richard Johnson.
Thank you.
Your Honor, at this time, I believe we'd like to set this matter for preliminary examination and all discoveries complete as far as we are aware.
People have their witnesses available the 27th.
We can try our best, but I wanted to make sure the court was aware. Mr. Johnson has 2 other cases that are already set for exam next week. That's a short turnaround, so again, we'll try our best to get our witnesses there, but I didn't know if we wanted to put them all together.
Now, is there a reason they need to be all together?
There's no reason, Your Honor.
So he has 2 set next week.
Yes, Your Honor.
Preliminary examination in person will be. So will the people have their witnesses available the 27th on this case?
We'll try our best.
May 27th, 2025, 9 a.m. That is before Judge Fresh Hour.
Thank you.
Bond in this matter will continue. Thank you. Calls case, People versus Antoine Coleman.
Good morning, Your Honor. Student Attorney Andra Sabri on behalf of Mr. Coleman, who is present in person today. State your name for the record, sir.
Antoine Coleman.
Your Honor, we are requesting an adjournment.
Why you you know what to do. Why just quit interfering until it's necessary? Just leave her alone. I feel like you know something. How much time did you want, counsel? Don't look at her.
Your Honor, we are waiting for him to complete his assessment for drug treatment court, so however much time the court sees fit.
See, you did that all on your own. You didn't need, she wouldn't have told you that. She would have started picking numbers. Which court is he waiting on an assessment?
14B, Your Honor.
All right, let's do it this way. Thank you, counsel, for informing me of that. That makes it easy for me. Unlike your supervising attorney, would you? June 5th, 2025, 9 a.m. Bond continue.
Thank you.
Thank you, Your Honor.
You're welcome, sir. Court calls the case, People versus Danielle Klimola.
Andrew Childers appearing on behalf of the people, Your Honor.
And Assistant Public Defender, really on behalf of Danielle Planola, who's approaching. Danielle, state your name for the record, please.
Danielle Klimola.
Thank you.
Your Honor, I am handing the court a plea form as well as the advice.
We don't get these before. But never mind. Court has before the plea form that indicates that the defendant will be pleading guilty to the charge of use of cocaine. That's a misdemeanor, 1 year misdemeanor of use of cocaine. Upon her successful plea to that charge, count 1 would be dismissed. There is the further indication that the defendant is to enter the 15th District Court sobriety court.
Your Honor, I don't know if this curiosity. So my understanding is the defendant is under sentence on her a year in jail. There may be an ask
That is correct.
for modifying that sentence.
Day?
Whenever the court, I don't know how the court would like for us to address it. We
I
can
wouldn't,
come,
but go ahead.
we can submit a motion to that effect.
You have to present a motion
Absolutely.
for that.
And I guess I'll put on the record right now, we have no objection to that and would be fine with the defendant's entry to the 15 sobriety court program, which she's been screened in.
All right. Okay, this is the court's full understanding of the agreement. Is that correct? From Curtis?
That is our understanding as well. Yes, Your Honor.
May I have her sworn?
Raise your right hand. You solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
State your name.
Danielle Claymore.
All right. Ma'am, it is this court's understanding that you are going to be pleading guilty to the charge of use of cocaine. That is a misdemeanor punishable by up to 1 year incarceration and $2,000 fine plus court costs. Do you understand that?
I do.
Drug possession cases often move quickly, but the consequences are long-lasting. A 1-year misdemeanor still means a criminal record, probation, testing, and potential treatment mandates. Judge Simpson is again ensuring clarity. There's no minimizing this charge. The court wants the defendant to understand exactly what she's agreeing to, especially since sentencing will occur in another court. Viewer question: should low-level drug cases emphasize treatment over punishment at this stage? Or does accountability still come first?
Understanding, and I also should advise you that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Valvo in 15th District Court. You understand that?
Yes, I do.
Still wish to plead guilty?
I do.
And to that charge, how do you plead?
I plead guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes.
You signed an advice of rights form. Is that correct?
Yes, I did.
Any question regarding those rights?
No.
Please look at paragraph 5. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on the form.
Yes. Yes,
You understand you're giving up your right to appeal of right.
I do.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plea?
No.
Anybody threaten you or coerce you?
No.
Doing this voluntarily
Yes.
of your own free will
Yes.
and because you believe that you're indeed guilty?
Yes.
March 18, 2025, a location on South State Street, City of Ann Arbor, Washtenaw County, State of Michigan. Did you have cocaine in your possession?
I did. Yes.
Had you used it?
Yes.
Did you know what you were using was cocaine?
I did.
Counsel, have I complied with the court?
Defense is satisfied as well, Judge.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed.
With that sentence, the case fundamentally changes. There will be no trial, no factual dispute. The focus shifts entirely to sentencing and supervision. Acceptance of a plea is a legal checkpoint. Everything before it can be undone. Everything after it moves forward. This is why judges are so methodical beforehand, because once this line is crossed, options narrow dramatically.
Thank you.
Pre-sentence investigation and report is ordered at 15th District Court. Probation sentencing will be
June 3rd at 10 a.m. with Judge Valvo.
June 3rd, 2025, 10 a.m. Judge Valvo.
And this was also in the email from Ms. Johns from the 15th District Court about possibly setting this on Friday. I don't know if the court gets those sentencing dates for 15th on Fridays. I'm sure they could also modify it. Judge Valvo could also set it on a different day. I know the court only gets so many days.
Yeah, I don't have that.
I only have June 3rd.
So we'll just set it that.
Yeah, okay, I'll just set it June.
And you're on the actually at 9 a.m.
Oh, it's at 9 a.m. before Judge Valvo. All right. Okay. Thank you.
Almost done. Thank you so much, Your Honor.
Court does call the case People versus Elijah Kraft.
And is in on behalf of the people, Your Honor.
She's back.
Good morning, Your Honor.
They gave
Student.
you a bunch of cases, didn't they?
Yes.
Did they?
Not a bunch, a fair amount.
Not a bunch? Who gave them to you? Did she give them to you?
I cannot confirm or deny, but I was assigned. I'm kidding.
Did Acting really give you all these cases? Did she say when she gave them to you, I don't want to do anything today?
No.
Oh, she didn't say that? Okay, I was just checking. All right, go ahead, counsel.
Student attorney Andra Sabri on behalf of Mr. Elijah Kraft, who is present in person with me today, Your Honor. If you could please state your name for the record.
Elijah Kraft. Thank you, sir.
Your Honor, we respectfully request that these matters be set for a preliminary examination.
Right. And on both of these matters, all your discovery is complete?
To my knowledge.
And would the people have their witnesses available to 27th?
We'll do our best, Your Honor.
Preliminary examination, May 27th, 2025, 9 a.m. That is before Judge Washington.
Thank you, Your Honor.
Right. Bond will continue. Thank you, sir. Court calls the cases of the people versus Dale Miller, 3 cases.
And Maggie, on behalf of Mr. Miller, who is approaching, please state your name for the record.
Dale Miller.
Your Honor, we recently have received a competency report, and we stipulate to findings of Mr. Miller being incompetent but restorable.
This phrase carries enormous weight. It means the defendant cannot currently participate in their defense, but might after treatment. The case pauses, not ends. Competency protects due process. You cannot prosecute someone who doesn't understand the proceedings. Judge Simpson's order balances treatment with future accountability. Audience question: should the justice system invest more resources here, or does this already represent fairness at its limit?
They've determined that he's incompetent to stand trial at this time, but likely to obtain competency through treatment. Is that correct?
Yes, Your Honor.
All right. All right, I have reviewed that report. I will sign off on those orders. I'll set a competency review hearing. I need 90.
90 days would be August 14th.
August 14, 2025, 9 a.m. Defendant's bond will continue.
Right. Thank you, Your Honor.
Thank you. Court does call the case of the people versus Martez Dalton.
Hannah Mackey on behalf of Mr. Dalton, who is, I believe he's riding a bus right now to court, Your Honor. The last we've heard, he was in downtown Ann Arbor 20 minutes ago. It's a slow bus.
He came from Detroit. Let him know he came from Detroit.
The bus has been driving from Detroit, Your Honor.
It's a slow bus.
Maybe it ran out of gas.
You ran out of- What?
He's coming. The bus is coming.
How do I know he's on a bus?
I spoke to him, Your Honor.
Huh?
I spoke to him and he said he was on the bus.
So what do you want me to do? Bench warn him?
No, Your
And
Honor.
we can go get him?
If you could please pass this matter for a few.
A few. Okay, so hold on. I went through this almost exact same thing with Cannon. And yes, I know, they had pictures all along of him on his bus ride. It was
So
like
it's a
trees.
common
It was
thing.
video. It was just trees going by a window on a bus. I don't know if it was on a bus. But at least they gave me pictures. Not you, nothing.
I'll provide photos, Your Honor, in a minute. It's clearly a common problem with buses. If Stephanie had the same issue with her.
Okay, Mackie, when's the last time you got on a bus?
For school, Your Honor. We ride a bus from the parking lot to class. It's like a mile walk.
When's the last time you got on a bus for travel around the city or?
New York. In New York. Subway, that's even better. Subway.
A subway is different than a bus.
Okay, I've never been on a bus, Your Honor.
I didn't think so. Okay, thank you. I'll pass it.
Thank you, Your Honor.
This sounds routine, but it's actually judicial discretion in motion. Passing a case is not leniency, it's controlled patience. Judge Simpson is choosing to wait for verification rather than rush into a bench warrant or punitive response. The court has heard the explanation about the bus, but notice what's missing: proof. Judges don't rule on vibes or stories. They rule on records. By passing the case briefly, the court allows counsel to substantiate claims without immediately escalating consequences. Audience question: should courts demand proof instantly, or is short flexibility appropriate when delays may be outside a defendant's control?
I've never been on a bus. I know. Don't know why you're trying to fight it. Just say I've never been on a bus. Court calls the case of the people versus Danielle Pressey.
Andrew Childers appearing on behalf of the people.
Michael Gaddy, Assistant Public Defender, on behalf of Ms. Pressey, who's approaching, Judge.
What's your name?
Danielle Pressey.
Requesting an adjournment.
Yes, Your Honor, there's a lot of discovery to go through.
May 29, 2025, 9 a.m. Bond continued.
If I could be heard on bond, Judge?
You may.
Thank you. Judge, I did have a chance to talk with Ms. Pressey. She is here before the court with a bond of, I think it's set at 150,000 cash.
A six-figure cash bond immediately signals severity. This isn't about missed dates or paperwork. It's about public safety risk. The court evaluates not just past behavior, but potential harm. Defense lists stability, employment, caregiving, all relevant. But bond is not a reward for good character. It's a risk calculation. And when loss of life is involved, courts lean heavily toward caution. Viewer question, should bond be about who someone is, or what could happen if they're released?
This is a situation where she has absolutely no criminal history the last 13 years or so. She does have an old OWI matter from 2012. That's all I could find on her CCH. She resides in the Metro Detroit area in Oxford or Lapeer. She owns a business, a brick and mortar business, a nail salon. She's not a flight risk in any way. She cares for her disabled mother. She is, like I said, gainfully employed. She owns a business, a nail salon that she is the proprietor of. She is. We'd ask the court to consider some kind of a reduction in bond, hopefully a personal bond, like if she would avail herself of any both a scram and a GPS tether if the court thought that was beneficial to ensure both her presence and that she's not anywhere that she should not be. She has, as I said, work, family responsibilities, and doesn't have to care for her disabled mother.
Response.
The facts of this case involve the defendant traveling around 60 miles an hour. It's on Marks Road, which I believe is 45, but it's probably 45 would be my guess. 60 miles an hour with now candidly the BAC was 0.038, but there was also 200 nanograms per milliliter of amphetamine, as well as THC, 2.7 nanograms of THC in her system. The victim is tragically the defendant's son, I believe was 7 at the time. He was improperly belted in the rear seat and killed in the accident. The vehicle crashed into a tree. Based on those facts and circumstances, I don't believe that the bond is improperly set. I believe that the facts of this case are awfully tragic, but I am concerned about the defendant's potential conduct while out this matter pending given the seriousness.
Your Honor, if I might, this is a very serious situation, very tragic. There was, the allegations of the purported Adderall, I believe, was a prescribed drug. As Mr. Childers stated, it was a 0.038 of what was the reported drug or alcohol. This was, like I said, this was a situation where I don't think she comported herself. This accident happened several months ago. She's comported back in December, I believe. She's comported herself properly since then. She'll continue to do so. As I said, she's not a flight risk in any way. And she does have responsibilities while we, there's a lot of information to look at here. And I believe this is a matter that is going to be litigated pretty heavily. So I'd ask the court to reduce the bond.
Motion for bond reduction is denied.
This is one of the most consequential rulings of the day. The judge explicitly states concern for public safety. That language matters. It justifies continued detention and limits future bond arguments unless circumstances change. Denial here doesn't mean guilt, but it does mean the court believes release presents unacceptable risk. That distinction is often misunderstood by the public. Audience question: should tragedy alone justify detention, or must risk always be forward-looking?
The court does consider the defendant a risk to public safety. And so her bond will continue. Thank you.
Thank you. Your Honor, if we did put together a written motion, would the people waive notice on that?
No, I'll wait notice as long as you don't give it to me at the end of the day on Wednesday.
No, I don't do that. Okay,
Yeah, as long as I have a fair amount of time to respond to that.
court consider hearing it early as well, Judge?
It will, when we receive the motion, Ms. Wagner will be more than happy to give you a date to hear it.
Thank you, Judge.
Court does call the case of the people versus Jordan Dave,
I'm sorry, Judge. I didn't catch the adjourn date. My fault.
29.
Thank you.
Jordan Davis.
Oh, that's you. I'm sorry. Okay, there. And is that on behalf of the people around?
And Mackie, on behalf of Mr. Davis, who's approaching, please state your name for the record.
Jordan Davis.
Your Honor, at this time,
No, I'll wait.
we'd like to set this matter for a preliminary examination,
All discovery is complete.
as far as we're aware.
People have their witnesses available the 27th.
Yes, Your Honor.
Preliminary examination in person, May 27th, 2025, 9 a.m. That's before Judge Fresh Hour.
Setting a preliminary exam means the case is moving forward, not resolving quietly. The prosecution must now show probable cause. Witnesses testify. Evidence is tested. This is the court saying the case deserves deeper scrutiny. It's a procedural escalation, and it raises the stakes for both sides. Viewer question: should more cases reach this stage, or do too many resolve before evidence is fully aired?
Thank you, Your Honor.
Thank you.
Bond will continue. Thank you. Recalls case, people versus Jeffrey Murphy.
Frank House is the prosecuting attorney on behalf of the people.
Good morning, Your Honor. Again, may it please the Honorable Court, David Burgess on behalf of Jeffrey Murphy.
All righty. Thank you for coming back, Mr. Burgess.
Yeah, of course,
Yes.
Your Honor.
Thank you, Your Honor, for recalling the case, and thank you to Mr. Burgess for jumping back on. Mainly, I want to make sure the defendant's not confused about how this process is going to work and what his bond conditions are. The victim was present here today in the gallery, and defendant decided it was a good idea to mean mug her as he walked by her. Here.
Sir.
Now, I know that this defendant has a history of abusing women sexually and physically, and apparently somewhere along the way, he has learned and decided that intimidating a victim of his crime is a good idea. Like I said, I think he's confused, so if we can clear some of that confusion, I would appreciate it.
All right. So you understand that? That
Yes.
you're not, and when the court is saying no contact, no intimidating or threatening behavior.
This is direct, public, and intentional. Judge Simpson is correcting behavior in real time, not privately. That matters. By placing this on the record, the court eliminates ambiguity. Any future contact becomes a violation, not a misunderstanding. This protects victims and preserves the integrity of proceedings. Audience question: should courtroom behavior carry immediate consequences or is verbal correction sufficient?
That applies both here in this courtroom and all of your behavior. You understand that, sir?
Yes.
And so if the alleged victim is present in the courtroom, I don't want you staring at them any kind of way.
I got you. I apologize.
All right? All right. Thank you. Thank you, Mr. Burke.
Yes, of course, Your Honor.
Court calls the case, people versus Harold Dennis.
Assistant Public Defender Jay Bellinger on behalf of Mr. Dennis. Mr. Dennis, can you please state your name for the record?
Harold L. Dennis.
All right, I have before me a plea form that indicates that the defendant would be pleading guilty to an added count 2 of larceny less than $200 to 93 day offense. Upon his successful plea to that charge, count 1 would be dismissed. There is no objection to sentencing under 77(1.1).
That is our understanding of the plea, Your Honor.
I have him sworn.
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give be the truth, the whole truth, and nothing but the truth? You got it.
I do.
State your name.
Harold L. Dennis.
Sir, it is this court's understanding that you're going to be pleading guilty to the charge of larceny less than $200. That is a misdemeanor punishable by up to 93 days jail, $500 fine plus court costs. The fine could be increased to 3 times the value of the property, which is the subject matter of the theft. If that's greater than $500, that would become the maximum fine. You understand all of that?
Yes.
You understand also, sir, that while I'm taking your plea, I would not be your sentencing judge and you would be sentenced before Judge Washington in the 14B District Court.
Okay.
You understand that?
Yes.
Still wish to plead guilty?
Yes.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
Yes.
You signed an advice of rights form today, is that correct?
Yes.
Any question regarding any of those rights?
No.
Look at paragraph 5. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights of for.
Okay.
You understand that?
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily
Yes.
of your own free will
Yes.
because you believe that you are indeed guilty of this offense?
Yes.
On the date of August 19, 2023, at the location of 1150 Nash Avenue, Ypsilanti Township, Washington County, State of Michigan, what'd you do regarding property belonging to Willie Rawls and Willie Rawls Jr. that makes you think that you're guilty?
Well, actually, I didn't do anything that,
Did you have an agreement with him?
yes,
And did you take his car as part of that agreement?
yes,
And as part of that agreement, you were to return that car within a specific amount of time?
yes,
And how long did you keep the car?
too long,
And how long is too long?
a couple years.
Okay.
2 years? Is that what you said?
Yes.
I'm just,
And was the value of that property under $200?
well, it doesn't matter.
I understand for the purpose of the
But-
plea, Your Honor.
So how long were you supposed to have the vehicle?
Well, there wasn't a determined time, but supposedly till I finished,
Till you what?
till I finished the job.
What job?
You were doing work
I
on the
was
car.
doing work on the car.
Oh, you were doing work on the car. And so then after you did the work on the car, you were supposed to return the car.
Well, I was not finished with the work on the car.
2 years later?
Well, yes, 2 years later. And
Did the owner of that vehicle have an expectation that you would turn that within a sufficient amount of time?
yes,
And did he contact the police as a result of you not returning the vehicle?
yes,
If I could briefly, were there multiple requests for the vehicle to be returned
Thank you.
that were not responded to?
yes,
And it's, so that we're really clear, the work that you were supposed to do would not take 2 years to complete,
No.
would it?
no,
In fact, it should have been completed well before that 2-year period,
yes,
correct?
yes.
You just didn't do the work.
No, actually, I did do the work.
He did some
Okay.
work,
Well, I didn't have it finished,
and the
but,
vehicle was returned after a few adjournments of the PCs.
and it was returned fully finished and in excellent shape,
But 2 years older.
which I was trying to do in the beginning.
Well, here's what I do. Yeah, there certainly would be a higher charge I could accept a plea to, given the facts of this case. So with that understanding, counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
Yes, Your Honor.
Yes.
Court will accept a defendant's plea of guilty to count 2. Count 1 is dismissed.
Another plea accepted, another life redirected. Acceptance closes the door on trial and opens the door to sentencing. This moment represents finality and efficiency. The court ensures rules were followed, then moves on. High-volume justice depends on moments like this. Viewer question: does efficiency here strengthen justice or risk overlooking nuance?
Pre-sentence investigation and report is ordered at 14B District Court sentencing
July 3rd at 10 a.m. with Judge Washington.
July 3rd, 2025, 10 a.m.
10 a.m.
10 a.m. before Judge Washington.
Okay.
Bond will continue.
You need to contact 14B probation as soon as possible. And that's your sentencing date. Okay, and time. And that's the location.
Where am I? And
You don't need to sign off on this one. That's just for you to keep for your record so that you know when to go to that court, okay? You can give me a call later. Oh, all right, take care of you later.
Build a car, geez. Just thinking.
Think about it.
Court calls the case People versus Barrage Scott. Bellinger, don't come up here with anything else like that.
Andrew Childers, on behalf of people.
We're ready in this matter, Your Honor. Lauren Brown, Deputy Chief Public Defender, appearing with and on behalf of Barrage Scott. Barrage, state your name, brother.
Barrage Scott.
All
How
right.
you doing?
How you doing, sir?
I'm okay.
You're doing very well, Your Honor. Your Honor, today is the date and time set for a competency review hearing. I do not believe that the report has been completed at this time. Does the court have?
I do not have a report.
So, Your Honor, we'd ask for an adjournment to see if that report can be.
Let's do this. Has he been interviewed at all yet?
Have it been?
Have he come talk to you, Mr. Scott?
From the forensic center, I'm confused.
Yeah.
Yeah, I went to the forensic center. and
Okay.
did a evaluation or something.
Yeah.
They took me from the jail.
Jail to
And
the,
then, yeah,
okay. So when did that happen?
like maybe a week or two.
Oh, just about a week.
Yes,
ago.
sir.
Okay, all right. So let's do this. Let's put you out. Still got to get a report. So I'll put you out. I'll set this hearing date. Indicating no report yet, but we'll set it for June 26, 2025.
So they won't be able to do anything until then.
Okay, that's fine. All right, sir.
So how you feel?
Yeah, but I'll set, which ones? They're both gonna be,
Gotta let him know.
Yeah.
No, she already had it. She passed acting something.
Okay, so we don't.
I'll just adjourn your probable cause to that same date of 26. I can't go ahead on that case anyway. Whether there's, I technically don't have a comp referral on the other matter, Mr. Brown.
Thank you.
I don't have a comp referral on the larceny of building case.
Oh, you
I
do not have.
do on the armed robbery case, but I can't do anything on that case with that other one pending anyway, but.
Right,
just so
right.
you
So,
know.
okay, we can do an order to match that one. Your Honor, what is my client's bond on this case?
On which case? On the larceny case, his bond is set at 1,000 cash or 10%. On the armed robbery case, his bond, I think it's denied.
You know, we would ask that the court do set a bond in this case. He does have very strong family support, as he has always had. Yes. They are pressing. We're asking that some bond be set for him.
Well, I think his bond got revoked on he was on bond on another case when this happened. So I'm not sure if he'd be entitled to have a bond in any respect because I released him and 8 days later, this case happened.
Okay.
So I'm going to decline to change his bond at this time. Let's get the report back and see where he is.
Report back. That's it.
So bond on these matters will continue.
Oh, yeah, absolutely. Absolutely.
All right. Thank you, Mr. Scott. Court calls the case People versus John Fleming.
Attorney on behalf of the people.
Good morning, Your Honor. Student Attorney Audra Sabri on behalf of Mr. John Fleming, who is present with me in court today. Record, sir.
John Fleming.
Where are the rest of his pants?
Hoping I'm going to work after this.
Your Honor, we
You'll
are,
talk to him about that afterwards.
will do, Your Honor.
Thank you.
You got a workload today, don't you?
Your Honor, we are requesting an adjournment.
Your Honor, we need a protective order in this case. There's a forensic interview of the child victim that I watched.
Okay. Is
I have received the protective order, Your Honor. I was just going over it. I'll submit it to the court.
Court.
Yes.
All right. So probable cause conference will adjourn to May 29, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Thanks, sir.
Thank you.
This docket day shows the justice system at work, not in headlines, but in process. Adjournments granted, pleas accepted, bonds enforced, warnings issued. Judge Simpson consistently prioritizes structure, clarity, and public safety. No theatrics, no favoritism, just rules applied evenly, case after case. The broader takeaway is this: court isn't about emotion, it's about record, behavior, and risk. Every ruling today reflects that balance. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.